time, please ask which question you want to have addressed first if you're unsure. So that's it from my side. It'll be 29 and 30. You guys know what sides you're on. So whenever you guys are ready, and if the judges are okay, the appellant may start.
May I proceed?
Proceed, counsel.
Thank you. Good morning, honorable justices of the court. My name is Laura Goldfarb, and I'm here with my co-counsel, Madeleine Cleland, on behalf of the appellant, K.J.M, in the case at bar. Today, we will be addressing the two key issues on appeal. First, whether the Jordan framework should apply to youth cases, and second, whether the delay in K.J.M's case was reasonable. Ultimately, we will ask that this court overturn the decision made at the Supreme Court of Canada, and to that end, we have 4 submissions for you. First, the establishment of Youth 11B ceilings is necessary to protect the rights of young people. Second, the establishment of Youth 11B ceilings is necessary to protect the Jordan framework. Third, the length of K.J.M's delay is properly calculated as 18 months and 28 days. And finally, in the event that this court calculates the delay differently, we will argue that it was nonetheless unreasonable and a stay should follow. I will be addressing the first 2 submissions about the broader applicability of Jordan, and my co-counsel will address the latter 2 about the appellant's delay specifically. Before I begin, Your Honors, do you require a brief summary of the facts?
We don't, and I'm going to jump right in here because I do find it interesting, counsel, that you say that it is necessary to preserve the Jordan framework to have a separate threshold here for young offenders. I would like to understand why it's necessary as opposed to the alternative, which is that we can still work with the Jordan framework and that there isn't any other alternative in place here.
Absolutely. So with regard to protecting the integrity of the Jordan framework, the court in Jordan set out to alleviate the serious problems under the previous Morin framework. Those were namely the unpredictability and extreme subjectivity attendant upon the notion of prejudice.
Aren't we creating more unpredictability by introducing new thresholds?
Well, in our submission, Your Honor, we're not. What we're asking for is 2 distinct, elegant, streamlined systems. We're not, in our submission, that would not logically give rise to any more ceilings. And that's because young people and only young people have their own separate justice system with a founding statute that codifies their enhanced need for timeliness.
Counsel, with all respect, you can't guarantee that there's not going to be other appellants seeking different ceilings. So isn't that a lot of conjecture saying that there's only going to be 2 proposed ceilings?
Well, Your Honor, I can't ensure what litigation will follow this decision. However, I can say with certainty that the only separate ceiling that would be logically based is a separate ceiling for young people. And that's because while there are other groups that, and individuals for that matter, that experience generally a heightened sensitivity to delay, there is no other group whose specific vulnerability to delay, whose specific skewed sense of time is acknowledged in statute, it's acknowledged in case law, it's acknowledged in international law. And it's—
Well, I'm going to stop you there, counsel, because there is one group. It's a pretty extreme statement to say that there is no other group, and that would be the interests of Indigenous groups, which isn't just found in statute, it's actually grounded in our Constitution. In other words, there's a very, very strong argument that there would be, right after this case is done, another challenge to create a different type of threshold. And so the argument that there isn't, that there's something absolutely unique about young offenders simply doesn't hold water here, does it, when we start looking at other groups like Indigenous peoples in Canada?
Well, Your Honor, Indigenous groups in Canada certainly have their own unique vulnerability, their own specific prejudice, but Indigenous groups, by dint of being Indigenous, do not have a distorted perception of time. And that—
Counsel, if I could just stop you there. I mean, we lawyers are pretty creative people. What's stopping the next appellant from saying that there should be just the same separate category given to seniors who arguably really face increased prejudice as a result of a longer trial, especially if they're suffering from a known health condition or if they're towards the end of their life?
Once again, Your Honor, in our submission, we certainly recognize that among the broader population, there are certain types of individuals who will experience greater prejudice because of delay. And we view the below the ceiling test as appropriate to deal with those individuals.
So I guess the obvious question then is, why is it different? How come other groups that face special privilege can be addressed under the Jordan framework, but youth cannot?
Well, because with young people, that heightened sensitivity to delay is not an exception to the rule, it is the rule.
But counsel, if I can push back on that again, for example, if you took a category of, let's say, people who are 80 plus, let's say 80 accused persons who are 80 plus, wouldn't you say that it is the rule more than the exception that they would be prejudiced by undue delay in their trial?
Yes, Your Honor, but there's no statutory or conventional recognition of 80 plus accused as a specific group in our justice system.
Thank you, counsel.
But there is for Indigenous people. So I think that's where we have a challenge here, is that it's very challenging to say that there is absolutely no other grounds. In fact, there's a very strong and compelling ground to create a different threshold for other individuals. And this is what the court, it appears to me, was trying to fight back here in terms of reforming Morin, is to get away from this multifactorial, multi-threshold approach and to have one standard approach. And here you are telling us that we should go back to a Morin-like framework. And I have some difficulty accepting that submission, counsel.
Well, Your Honor, I'd answer that question in two parts. The first is to reiterate that Indigenous people do not have the specific prejudice resulting from a distorted perception of time that young people do. They do experience—
That is simply one factor. And so, as I said, with Indigenous people, we have constitutional considerations, we have restorative considerations. The Gladue case, which isn't mentioned in this particular case, but it's very well known in terms of those considerations, enunciates the reasons for why we need to have a special lens and a special approach. And so what I'm going to suggest is that perhaps in the interest of time, you move off this argument, move off the position that there is no other grounds for which another threshold could be created, and that you continue with your submissions.
Thank you, Your Honor. In our submission, the establishment of separate ceilings for young people is necessary to protect the rights of young people, because keeping those young people within the grasp of the Jordan framework would place a disproportionate persuasive burden on them relative to adults. And Your Honors, to illustrate this, I would point to the way in which the ceilings function. Under Jordan, delays that are above the ceiling are presumptively unreasonable. However, delays below the ceiling are made presumptively reasonable. Now, this scheme works well for adults because it benefits them with the presumption of unreasonableness in most instances where their delay would historically have been deemed unreasonable.
And so, counsel, if I understand then your submission is, because that presumption exists that it is reasonable underneath that threshold, it's somehow disadvantaging young offenders. However, the fact that we have a statutory scheme focusing on young offenders with specific considerations means that rebuttable presumption may in fact be rebuttable, correct?
Yes, absolutely. However, the fact that the burden may be slightly lighter for young people than it is for adults is, in our submission, a mere token advantage compared to the disadvantage of having to bear a persuasive burden in instances where they shouldn't be. Simply put, when we look at the pre-Jordan—
3 minutes remaining.
Thank you. When we look at the pre-Jordan jurisprudence, we see that delays in youth court have historically been deemed unreasonable well before that 18-month mark. And this means that young people and not adults now have to now have to contend with a presumption of reasonableness for delays that have historically been deemed unreasonable for their group. Your Honors, the below the ceiling test is an important part of the Jordan framework, but it was not intended or equipped to be the primary means of enforcing timely justice for young people. Using it in that way is a subpar, improvised solution that treats youth rights as an afterthought. Moving forward, Your Honors, in our submission, I've already addressed my second submission about why, in our view, the Jordan framework would be harmed should young people be subsumed under it. But just to add on to that, once again, the reintroduction of prejudice, rather establishing a separate ceiling in line with the traditional distinction between youth and adult justice, would not create a slippery slope. Establishing or reintroducing prejudice as a permissive factor in the below the ceiling test, that would open the door for any other accused
1 minute remaining
to demand special treatment. It's on that basis that we say that keeping young people within the Jordan framework is a much greater departure from Jordan than would be establishing separate ceilings. I see I'm coming to the end of my time. May I ask for a brief indulgence just to conclude?
Proceed.
Thank you. In conclusion, Your Honors, we would ask that this court establish a separate presumptive ceiling of 15 months for young people, and that reflects the guidance provided by Justice Osborne in the Crown and M, and it reflects, most importantly, the enhanced need for timeliness in youth matters. Barring any further questions for me, this concludes the appellant's first submission, and I'll now hand it over to my colleague to address the latter two. Thank you.
Good morning, honorable justices of the court. Again, my name is Madeleine Cleland, and I will be addressing the final two submissions on behalf of the appellant, Mr. K.J.M, in the case at bar. Your Honors, the appellant's final two submissions, to reiterate, are first, that the length of my client's delay is properly calculated at 18 months and 28 days. And second and finally, that this delay, even if the court decides to calculate it differently, satisfies the below the ceiling test stipulated in the Queen and Jordan, and a stay of the proceedings should be nonetheless granted. Your Honors, as I'm sure you're aware, the first step in calculating the delay experienced by my client, K.J.M, is to calculate the total delay from the day he was formally charged until the actual date of the end of trial. Your Honors, from this total are subtracted defense delay and delay caused from discrete exceptional events. In this case, pre-subtraction, the total delay was 18 months and 28 days. The majority of the Supreme Court of Canada attributes 2 to 3 month delay to K.J.M's late arrival to court on March 2nd, 2016. I understand this is a point of contention in the case, and so my submissions will follow. Your Honors.
Counsel, if I understand your submissions, then we're really looking at 18 days above an 18-month threshold then, right?
Yes, Your Honor, 28 days above the threshold.
Sorry, 28 days, yes.
Yes.
And so that's a relatively insignificant amount of days, especially if we are looking at a transitionary case, a case which very much was contemplated and considered by all the parties involved to fall under the Morin guidelines and framework as opposed to the Jordan framework, because Jordan came out later. So this is not an egregious delay by any means, is it?
Well, certainly, Your Honor, that would not be our submission, as we would contend that a lower ceiling should be applied, as my co-counsel has already attested to. However,
but if we don't accept that submission, then we're still looking at just 28 days, correct?
Above the ceiling, yes, Your Honor. It's a strict ceiling as prescribed by Jordan. However, we do contend that any amount above Jordan, as is prescribed by Jordan exactly, is unreasonable. And for that example,
well, it's presumptively unreasonable is what we heard.
Presumptively.
Right? And so what I would like to hear is, we're going to hear submissions from your friends shortly, but I would like to really understand why 28 days, being presumptively unreasonable, cannot be rebutted. That's really what I think is at play here in terms of the respondents' submissions.
Your Honor, at this point in time, I would contend that the 2 to 3 month delay that I'm sure my friends for the respondent will make in tune with the majority's decision is what is the point of most contention, as the subtraction of that 2 to 3 month delay puts my client's case underneath the presumptive 18-month threshold. And that's what I would like to focus on here, Your Honor, because it is the point in most contention. And as I will contend that 28 days may not make the most significant impact upon my client's case, as without it, it's still above the presumptive threshold. So I won't focus so much on the discrete exceptional event.
I'm very, very interested about why 28 days is so significant, especially when we're looking at a very, very serious crime here, and how a stay would potentially put the justice system into disrepute in terms of the mind of the public for a serious crime.
Certainly, Your Honors. At this point in time, attuned to my co-counsel's submissions, we do contend that any delay above 15 months is unreasonable for a young person. However, 28 days above this 18-month threshold, especially considering the transitional nature of this case, where the Morin framework prescribes an 8 to 10 month threshold, is 8 months and 28 days above that, or perhaps 12 months and 10 days.
So are you suggesting that for transitionary cases, we should be applying greater scrutiny or less scrutiny, more flexibility or less flexibility for transitionary cases?
Your Honor, for transitionary cases, we would submit that the appropriate approach is to, first, I would submit, Your Honor, that applying the Jordan framework and the below the ceiling test in this case, or those considerations stipulated in Jordan, but also to take into consideration the pre-Jordan jurisprudence and how that applies to the transitionary case at hand.
I would love to hear more about the pre-Jordan jurisprudence, specifically in terms of how transitionary cases were dealt with previously.
Certainly, Your Honor.
That would be a very interesting submission.
We do recognize that the fact that this case is transitionary plays a big part, and the fact that I'm sure my friends will attest, or the fact that majority attested, that they've quantified 80% of this trial to have occurred pre-Jordan. And pursuant to that, in the transitional exception, we provide a deeply contextual analysis. Your Honors, pursuant to this acknowledgement, I will assent to the framework established by Justice Veldis at the Alberta Court of Appeal, reflecting the priority of pre-Jordan jurisprudence and how that comes into play in my client's case. Your Honors, Justice Veldis, the Justice at Supreme Court, Alberta Court of Appeal, and the dissent there prescribed that we consider the following 4 factors in reflection of the pre-Jordan jurisprudence priorities. First, being the complexity of the case. Second, being the delay relative to the Morin guidelines, which were prescribed at that time. Third, the party's response to the delay. And fourth and finally, the prejudice to the accused. In the analysis of the 4 factors, I will proceed, Your Honors. The first factor being complexity. I'm sure we can all come to the consensus that this case was not overly complex or burdensome, turning relatively on the issue of self-defense, whether my client was acting upon it in his assault. It weighs in favor of a stay of the proceedings. Second, the delay relative to the Morin guidelines. And in this case, 12 3/4 months have been attributed to institutional and Crown delay. This exceeds that 8 to 10 month prescription pursuant to Morin. This also weighs in favor of a stay. Third, the party's response to the delay. And Your Honors, what we can see here is in Jordan prescribing that counsel acts reasonably and not perfect, we would submit that counsel for my client at trial acted within those prescribed guidelines. And fourth and finally, Your Honors, prejudice. And this is a term we see come up frequently in this case, especially by my co-counsel and Your Honor's concerns. While we do recognize that counsel for my client and appellant himself led no evidence of prejudice, we in this court and the justices at all other levels of this trial can recognize that young people are more predisposed to prejudice, as is reflected.
So you're asking for a presumption of prejudice. Can we also make an assumption then that, or presumption more accurately, that when an accused shows up late for a court appearance, that there is going to be ripple effects on the justice system that will adversely impact other members and other parties in the justice system, including other accused.
We certainly understand your concerns, Justice. However, at this point in time, we do understand that young people should be held responsible for the crimes they commit. However, this should not be ever at the expense of their charter protection.
Well, not just for the crimes they commit, but also for their participation in the justice system. That's what we're looking at in terms of the Jordan framework and the Jordan principles, is the conduct of all of the parties, including the accused. And in this case, you'll agree with me that your client doesn't come to this case with clean hands.
Certainly, Your Honor, and although I will say that the Queen and M pointed out that there is a reduced connection between actions and their consequences for young people, I would submit that Your Honors consider this precedent when evaluating my client's conduct. However, I do understand your concern of our proposition that 0 months be attributable to the defense delay. However, I will point Your Honor's attention to the fact that the 2 to 3 month delay quantified by the Supreme Court of Canada as defense delay, we submit that it is based solely upon conjecture. Your Honors, a continuance for this date of trial was inevitable. I'm sure my friends will concede this at some point in the middle.
But it's no less conjecture, counsel, than the submission you just made about time and the impact of time on young offenders, right? It's all conjecture, and that is part of what the court needs to analyze, correct? Is the presumptions and how the impact on the justice system may be affected here. So all of your submissions are really based on conjecture.
Your Honor, I would have to respectfully disagree that the fact of the burden of
3
time.
minutes remaining.
Thank you. The burden upon young people of time is more enhanced pursuant to Section 31B4 of the Youth Criminal Justice Act, wherein timely intervention is codified as a necessity for young people. This is
Counsel.
a action. Yes, Your Honor.
Justice Ha-Redeye's comment with respect to disrepute of the justice system is of particular interest, and I want to focus on this 2.5 hour delay. Would you agree with me? We're not talking about a minute 15-minute delay. We're talking about 2.5 hours, which is essentially in provincial court, an entire morning. All right? And this is not simply that there could have been other time found. You specifically read in the Supreme Court decision that to change that 2.5 hour slot to a 5 hour full day time slot, you know this as counsel, that full day time slot is nearly impossible to find. So I can tell you, counsel, that my beliefs are that you are lucky that the Supreme Court deducted half the time. I would have deducted the entire 5 months from that time period. So what is your position on that, counsel?
Your Honor, as much as I do respect the fact that as legal counsel ourselves and yourself as a tried lawyer, the fact is that no one has led evidence that this 5 hour time slot, this 2.5 hour time slot would have been easier to procure.
Counsel, you're talking to me about evidence. We're talking about practical realities of court and trial. And Justice Ha-Redeye has spoken about the justice system into disrepute. I can advise you, counsel, that I believe that the 2.5 hour delay is alone justification to dismiss your appeal.
Your Honors, at this point in time, we would...
1 minute remaining.
Thank you. We would submit that although we recognize that my client's conduct at trial may not have been the most favorable, and I'll use the terms of Justice Ha-Redeye, that he did not come to the court with clean hands in this appeal. However, we must look into the fact that this is not an average trial. This is dealing with a child's chartered rights.
A child who had counsel, correct?
A child who had counsel, Your Honor, yes.
So where was that counsel to ensure that his client was there on time? And what was the rest of the court to do with that time slot? To do interim matters without the accused? Again, this is unacceptable. So the question here I have for you is with respect to these very scarce resources with court, how do you intend to reconcile that in your argument?
Your Honors, I do see I'm coming to the end of my time. May I have a brief indulgence to answer Justice Ong's question?
Yes.
Thank you. Your Honors, at this point in time, we recognize that there's institutional delay rampant at this time, and also that court resources are scarce and should be used sparingly when necessary. However, when analyzing the actions of a child, we cannot put the weight that we would on an adult. I will point again to the deduction made at the Queen and M that young people do not make the same connection between their actions and the proposed consequences. I cannot get into the mind of my client and think what he was thinking at that time. However, a reasonable assumption might be that he didn't have to have his charter rights infringed by having a 5-month delay from a 2.5-hour late. Your Honors, I'll briefly conclude that the proper calculation of the delay experienced by my client is 18 months and 28 days. Further, although I didn't get to it, a proper calculation of the stay below the ceiling test, if Your Honors calculate the delay differently, favors a finding in favor of the appellant today, Your Honors. And barring any further questions from me, this concludes the appellant's submissions. Thank you very much for your time.
Thank you, counsel.
May I proceed?
Yes, proceed, counsel.
Good afternoon, honorable justices. My name is Justine Scobie, and along with my co-counsel, Samuel Pevalin, we will be representing the respondent, Her Majesty the Queen, for the case at bar. It is our position that the Supreme Court of Canada made the correct decision in the case of the Queen versus K.J.M. Our order sought is that the Supreme Court of Canada uphold the lower court, that our order sought is that the Supreme Court of Lions Cup uphold the lower court's ruling and dismiss the appeal. We have two submissions today. First, that the delay in the appellant's case was reasonable and so stay should not be granted. Second, that the Jordan framework accommodates the need for timeliness in youth criminal justice trials and therefore applies to youth cases. I will address the first submission, and my co-counsel will address the second. %80 of this case was in the system before Jordan was enacted. It is in Jordan that cases that were currently in the system fall underneath the Jordan framework, and the Jordan framework applies. The first step in the Jordan framework is to calculate the overall delay elapsed in the proceedings.
So, counsel, we're very familiar with the Jordan framework. I think I'm going to move your submissions along. Is it your submission that this is a transitionary case, and in that context, we need to evaluate it in light of the fact that it's a transitionary case?
Certainly, Justice.
So can you please move to those submissions?
The overall time elapsed for the case was 18 months and 28 days. However, we contend that deducting 3 to 4 months in total with defense delay and discrete exceptional events brings the case down to 15 to 16 months and therefore necessitates a below the ceiling test to decide whether a stay should be granted or not.
And 15 months, in your estimation, is actually an expeditious trial?
Considering the circumstances at that time and the pre-Jordan framework that fostered a high tolerance for institutional delay, that's exactly what I'm contending, Justice.
So when you talk about the circumstances, that's what Jordan and subsequently Cody were referring to, is that we have a justice system that does not serve our public. It's endemic, there's systemic delays everywhere, and yet you're saying that a stay is not appropriate in this case.
That's exactly what I'm suggesting, Your Honor, because Jordan was enacted 80% into this case, and 80% of this case took place before Jordan when there was a culture of complacency within the institutions. And given the context of this case, the tolerance for delay was high. But tolerance to delay was not the only factor that was yielded to in this situation. There's also the seriousness of the offense and the lack of prejudice. Now,
Are charter rights impacted by the culture that surrounds them? So if there's a culture that tolerates a charter right not being enforced, are we supposed to just shrug our hands and say, well, I guess that charter right isn't enforced to its full potential?
Not quite, Justice. What I'm suggesting, or what I'm contending, is that the Jordan framework sought to address and guarantee Section 11B charter right. Previous to that, the Moot framework fostered a culture of institutional delay, and 80% of this case yielded to that, including the prejudice, the lack of prejudice, and the seriousness of the offense. Now, one thing to consider is that although 18 months and 28 days was the total time that was elapsed, three to 4 months should be deducted from that total. Firstly, due to defense delay. And we completely agree with Justice Ha-Redeye in that it is the defendant's responsibility to show up on time and respect the criminal justice system. With the defendant showing up 2.5 hours late, indeed, there was a continuation of trial that was necessary. However, it would have been far easier to rebook 2.5 hours for a trial rather than 5 hours. Secondly, the discrete exceptional events. 1 month was deducted from the 18 months and 28 days due to discrete exceptional events. And that was because it's stated in Jordan that a discrete exceptional event is considered reasonably unavoidable or reasonably unforeseeable from either the Crown or the justice system. Now, the Crown, I'm asking the question of the Crown. The Crown reversed its position absolutely. And in that aspect, we are not deducting any of the time from the Crown reversing the position, which further bolsters our contention that the defense should also be held accountable.
Counsel, I hear your argument, and I take particular interest with when you said that under the Moran framework, there was a culture of delay. And you've conceded that with the 80% of this case being tried under that framework. So here's my question. You are arguing for maintaining the Jordan framework in the present form, correct?
Yes, Justice.
Okay. How do you reconcile those two statements? 80% of the case happened in a time of institutional delay. You are now saying that we should keep the Jordan framework. So if we don't give the appellant their appeal and give them a lower framework, aren't you essentially admitting that we have failed the youth?
Not quite, Justice. In fact, in Jordan 1, paragraph 100 and 101, it stated that the tolerance for institutional delay makes it substantially more difficult to grant a stay beneath the ceiling, given the local tolerance for institutional delay. And it was evident at this time that Fort McMurray was backlogged and suffered from endemic delays. However, the Jordan framework also said that you have to yield to the pre-Jordan state of law, which at that point in time, there was a serious offense that was committed by the defendant, and it's in societal interest to ensure that the proceedings were carried out in such a way that resolved the issue with merit. And secondly, that the prejudice when dealing with youth certainly is a consideration. However, there isn't evidence really to suggest that there was prejudice within the case at bar. In fact, the defendant was only in the pretrial detention center for 9 days and then was released with minimal conditions. So it's fairly unreasonable to suggest that there was prejudice suffered. And that brings me back to the failure to satisfy the second step in the two steps.
Sorry, counsel, don't we assume, as we've just heard from your friends, that there is some prejudice simply by the fact that young offenders are having their rights affected, and the fact that, as we've seen in previous cases, a trial or the prospect of a trial itself creates prejudice? That was referred to, for example, in Askov, one of the previous cases.
Certainly, Justice. It is absolutely reasonable to assume that there is prejudice. However, this is an extremely gray area to enter, and it's in our best interest to rely on the evidence of prejudice in this case. And
so if it's a gray area, why don't we have a rebuttable presumption for young offenders, as we've heard from the appellants here? Then that way we avoid the gray areas. We have a second threshold for young offenders. We avoid the gray areas. We streamline these proceedings. Jordan wasn't simply a matter of saying there's a culture of complacency for everybody. It was also a matter of saying enough with these motions that are also taking up the time. If we have another threshold for young offenders, we don't need any more motions to look at the prejudice.
Sorry, Justice. So are you asking how does the
3 minutes remaining.
Justice, so are you asking how does the Jordan framework account for the prejudice that youth are suffering?
What I'm asking for you to do is respond more directly to why we shouldn't have a second threshold for young offenders.
It is our contention that a second threshold for young contenders is unnecessary because Jordan currently accommodates the need for timeliness in youth proceedings, and my co-counsel will elaborate on that in great extent. However, our contention is that relying on the pre-state of law, which in this case is reasonable, and 80% of this case took place before the trial, the principles of Jordan in fostering a more expeditious culture in the criminal justice system, a change like that doesn't happen overnight. 80% of this case took place before Jordan was enacted. And to expect that this case were to proceed more expeditiously under that complacent culture within the criminal justice.
Well, counsel, that's exactly the reason why we started these submissions, with me asking whether or not this should be treated differently because it's a transitionary case. If it was to be treated differently, I would think that that would favor the accused and that stay should be granted. Is that not correct?
A state shall only be granted beneath the ceiling if it passes 2 steps in the Jordan framework. The first step is that did the defendant maintain sustained efforts to expedite the proceeding? We'll give them the benefit of the doubt given the current circumstances. Defense is expected to act reasonable, although not perfectly, as stated in paragraph 85 of Jordan.
Ms. Scobie, I'll ask you a follow-up question that's further to Justice Ha-Redeye's. So do you see a legislative problem with 2 ceilings?
Our contention, Justice.
1 minute remaining.
She can have another minute.
No. Thank you, Justice. Our contention is that, sorry, can you repeat the question?
Do you believe there is a legislative problem with granting 2 ceilings? And I'm specifically talking about the difference between the criminal law system in addition to the Youth Criminal Justice Act.
Justice, our contention is that we don't see an issue with, that we do in fact see an issue with the legislation that would surround fostering a second presumptive ceiling for youth.
Why? Why do you see there to be a problem?
Because, Justice, if we adjust this constitutional right, as you have asked our friends, this could in fact lead to a multiplicity of other ceilings. And
but there's a multiplicity of statutes. There's the Criminal Law Act in addition to the Youth Criminal Justice Act. So what's the problem? Why is there a legislative problem?
Justice, perhaps that could be something that would deal with. However, the issue at bar right now is that the youth criminal justice system was folded into the Jordan framework, and the Jordan framework provides a flexible and robust system for accommodating stays beneath the ceiling.
Counsel,
counsel, you may. Sorry.
I was just going to change it a little bit. So if the court below, if the court in Jordan intended to give this leniency that you're suggesting, that we kind of let some of this complacency or delay go, why did they put the transitional cases presumptively under the Jordan framework?
Sorry, Justice, can you please repeat the question?
So the fact that the court in Jordan said that transitional cases kind of presumptively fall under the Jordan framework, if you think about it, it's kind of retroactively applying limits to cases that are before, which is something that the court only does when it sees a really pressing need to do so. Would you agree? So I guess what I'm asking is, if the court really wanted to give transitional cases the leniency that you are asking us to give your transitional case, why did they say that those transitional cases should fall under the Jordan framework at all?
Time.
Oh, okay. Well, I'm sorry.
Justice, may I have a moment to answer the question and then to conclude?
Moderator, I'll let the moderator answer that.
Yeah, that's okay.
Okay, since my time is elapsing, Justice,
You can just give a brief answer.
certainly. The Jordan framework provides a robust and flexible approach to granting stays beneath the ceiling in reasonable circumstances. And the second step in the Jordan framework is to ask whether the case took markedly longer than it reasonably should have. And given the context of when this case was going through the system, and I might add that Jordan was enacted in July 2016.
Thank you, counsel. Thank you, counsel.
Hey, where are the timelines? That's the answer I was looking for, counsel.
Thank you, Justice.
Mr. Scobie, before we get started, I'm going to ask that you remove your lapel pin, if you don't mind.
Oh, yeah, for sure. Forgot I was there. Okay. Yeah, so we're using the same camera because we're in the same room. So I'm Mr. Pevalin. May I proceed?
Counsel, go ahead.
I apologize for mixing up the names. Counsel,
Yeah.
if we're getting started, I'm going to take you directly to paragraph 85 of Jordan, simply because that's where your co-counsel had left arguments. And I'm going to quote directly from there. It says, the defense benefits from a strong presumption in favor of a stay once the ceiling is exceeded. I suspect that your submissions are going to be affected by that particular statement, and I'd like for you to explain to me why we shouldn't be giving that benefit to the defense, given that you yourself have relied on that specific paragraph.
So, Justice, the reason why we're not going to give the defense that particular benefit in this case is that Jordan also lays out in paragraph 99 that in a case which is a transitional exception but is above the presumptive ceiling, we have to be mindful of the institutional delay that was endemic within the system before the enactment of Jordan. Paragraphs 100 to 101, it states that institutional delay is part of what constitutes a reasonable time for a trial. So with that in mind, we would deny a stay in this proceeding.
Well, counsel, I'm going to stop you there because paragraph 99, which you just referred to, says the defense need not demonstrate having taken the initiative to expedite matters. And the reason for that is in the Morin framework, that was not required. So the fact that 80% of this matter proceeded under Morin, that benefits the defense here, doesn't it?
So no, the defense need not take those steps to expedite the trial, and that's why when we apply the two-step framework in Jordan, we give the defense the benefit of the doubt in satisfying step one. However, the Morin framework fostered a culture of complacency, which led to these endemic delays. And sorry, could you just repeat the second half of your question, Justice, please?
The point here is those endemic delays pre-Jordan were placed in the hands of the Crown. And so it is very difficult to hold the defense accountable for delays that under the Morin framework they would not have been responsible for. This is a delay that should benefit the defense. Is that not correct?
Justice, no, it's not. And part of the reason for that is that Morin set out a guideline that anything more than 10 months is considered an unreasonable delay. However, the onus was always on the defense to prove why this case was taking longer than it should have.
Well, then I'm going to turn you back to the decision and the paragraphs in particular that you cited. And paragraph 101 said, the reasonable time requirement of the case must reflect this high level of tolerance for institutional delay in particular localities. And in this locality that we're looking at, Fort McMurray, this was a very significant concern. It was very well known that there were endemic delays there. That is not the fault of the defense, is it not?
No, it's not. And at paragraphs 101 of Jordan, it also says, though, that because of those endemic delays, a stay is going to be even harder to grant because those institutional delays are part of what constitutes a reasonable trial. It's unfortunate that for our client that that's the case. It's unfair, but it's not necessarily unjust. And part of the reason why the Jordan framework is so, why we advocate for it so strongly today, and while I'm going to explain how it accommodates the need for timeliness in youth trials so that this doesn't happen again, is the introduction of the presumptive sealing, which was absent in Morin. In Morin, as I mentioned, the onus was always going to be on the defense to explain why this trial was taking so long. With the introduction of an 18-month presumptive sealing, the onus has effectively switched from the defense to the Crown to explain why this case is taking the time that it did. With that in mind, as we consider the need for timeliness in youth cases, which brings me into the thrust of my submission that Jordan is an accommodating framework and can accommodate this need for timeliness in youth cases, this sealing accounts for the prejudice that youth will feel and creates a universal sealing. However, the tolerance for delay is going to be different, but Jordan gives us a case-by-case basis.
Counsel, I'm just going to stop you there. So I appreciate your argument about the onus switching, okay? But the practical reality is either these trials happen sooner or they don't. Do you agree with me?
Yes, Justice.
So you can sit here all day and present to this honorable court that you know, having an 18-month sealing presumptively assists the defense, but at the end of the day, the trial is either taking place or it isn't. So don't you believe under that particular argument that there is a need to create a separate sealing for youth?
Justice, I do not believe that we need to create a separate sealing for youth. The reasons for that are many. The first that I would like to point to, and also to respond to what my friend said about pre-Jordan jurisprudence, saying that youth need to be tried in a more expeditious manner. The case of the Queen and DS in 1992 at the Supreme Court said that although young offenders need to be proceeded with promptly, it's just one factor to be considered among others. We have to weigh things such as the seriousness of the offense. When our friend cited this pre-Jordan jurisprudence, that Supreme Court case, the Queen and DS, which I just cited, is the only Supreme Court case pre this specific case which dealt with the issue of granting separate presumptive sealing for youth, and it suggests otherwise. As well, part of the reason why we don't need to have a lower presumptive sealing for youth is that the Jordan test for a stay below the ceiling, the two-step test, accommodates that need for timeliness in a youth trial. Our friends maintained that...
Does not suggest that youth will be disproportionately vulnerable to having the onus placed on them to show that the prejudice they suffered warrants the below threshold test? Does that concern you if that's the case?
Justice, no, because under the Morin framework beforehand, as we were previously discussing, there was no presumptive sealing. And while, yes, the onus is going to be on them to explain, that's just part of having a presumptive sealing. When the onus switches to the Crown after 18 months, it's fair then that the defense would have to advocate for why this case needs to be granted a stay below the ceiling.
So, counsel, I'm going to move you back. Sorry, go ahead.
Sorry, I'll yield to Justice Ha-Redeye.
I was going to try to help the submissions here in terms of moving you back to what I think your focus is, which is how we actually attribute the delay. And I think what we might want to hear is whether or not there even should be a transitional period. And in that light, I'll turn you to the dissent in Jordan, so paragraph 287, where it talks about transitional provisions creating a charter amnesty, and how the previous decisions in the court, and more in looking at the Ascov framework, had very significant concerns about creating a transitionary amnesty as it relates to charter rights, because that's what it sounds like you're proposing here.
Justice, no, I would not submit that we're creating a charter amnesty for transitory cases. Charter rights develop over time and they change. We've read in certain provisions, such as anti-discrimination against LGBTQ plus groups into Section 15.
Counsel, I have no question in my mind that charter rights will change, and this provision will continually be interpreted over the years. The problem that we have here is that it is the state that is changing the interpretation. It is the courts that are changing this interpretation, and the state is the one that actually is responsible for the bulk of the delay here pre-Jordan. And so why are we not providing that credit to the accused in this case?
It's because the Jordan framework, as it is, it says from paragraphs 100 to 101 that institutional delay is part of what is going to be a reasonable trial time in this case. It's unfortunate, but we can't retroactively apply the law. We cannot take today's head and put it on yesterday's shoulder. That's not how our common law system based on precedent works. And
Isn't that what you're doing here, though, in your submissions, by trying to hold the defense accountable for these delays? You're effectively saying you should have known Jordan was coming. You should have preconceived what the court was going to say. They should be evaluated under the Morin framework, and under the Morin framework, this would have received a stay. Isn't that correct?
3 minutes remaining.
Thank you. It's our position that under the Morin framework, that wouldn't be granted a stay, because not only do you have to consider the prejudice that the youth felt, but you also have to weigh the seriousness of the crime. And in this case, it's our position that the seriousness of the crime outweighs the prejudice felt. So under the Morin framework, this wouldn't have been granted a stay.
Okay. But that's not my question. My question really is that under the Morin framework, the conduct of the accused, the conduct of the defense doesn't take a priority in the same way that it does in Jordan, right?
No, Justice, no.
And so then why should we be giving any weight or much weight at all to any delay that is attributable to the defense when 80% of this happened under the Morin framework?
Justice, could you just rephrase the question for me? Sorry.
If 80% of this matter occurred under the Morin framework, which did not scrutinize defense conduct, why are we putting such a significant impact on defense conduct in this matter now that the Jordan framework has been released?
So as a transitional case where 80% of this case was before Jordan, we're putting the conduct on the defense because that would bring it below the presumptive ceiling established in Jordan, which then reverts us to the Morin framework. And as we submit under the Morin framework, this case would not be granted a stay. I will, however, given that my time is elapsing.
1 minute remaining.
1 minute remaining. May I just have a minute to another?
Counsel, maybe you can help me with the concern that I'm having. The Supreme Court in Jordan said that the below the threshold test should only be met in kind of rare circumstances.
Yes.
Is your position that these rare circumstances apply in most or all youth criminal proceedings, or what proportion of youth criminal proceedings benefit from a lower time limit for a trial? In your position.
So no, Justice, that's not our position, and I'm going to explain that for two reasons. The first is we have to be conscious of the fact that already youth trials are given priority in the criminal justice system and are dealt with more expeditiously. For that reason, there's no evidence of any endemic delay in youth trials at the moment, which brings me to the second point of my submission and to refute my friend's claim that the two-step test wasn't supposed to be the primary means which enforces youth 11B rights, is the fact that given already this practice of prioritizing youth trials, the stay below the ceiling will be rare, because not only will it be rare in youth trials, but youth trials also compromise a smaller part of the criminal justice system compared to adult trials more broadly. So in that,
So you're saying that it will be rare because in practice, not that many youth face delayed criminal trials. Well, what about maybe like in the future, maybe in a couple of months, once all the courts come back up, maybe we will start seeing a bunch of youth criminal cases get delayed. How rare will it be then?
So we submit to you today that that could be a possibility. I'm not here to plan ahead to make those kind of predictions, but that would only be temporary given these exceptional circumstances of a global pandemic. I don't think any of us really saw that when Jordan came in. Thank you. May I just have 1 minute to conclude? Proceed. So in this case, it is our submission that the Jordan framework accommodates the need for timeliness in youth cases. You know, I think it's important as we sit here and we discuss constitutional standards, Morin framework, but that we never divorce ourselves from the human aspect of this case. We are talking about young offenders who have the misfortune of being in the criminal justice system. And as representatives of the Queen, we're not here to lay down the iron fist of the law. We're here to help these young offenders. But we just submit to you today that we have a framework that does that. And what this case is about is using a framework that has been established and has been proven to help young offenders realize their Section 11B rights. And that's today why we ask you to dismiss the appeal from the lower court. Thank you, Justices.
Thank you, counsel.
Thank you very much. I will ask the competitors to please exit this call. The judges have about 6 minutes to deliberate. The next